Hello, welcome to 39 Essex Chambers and our Covid-19 business interruption insurance, the Supreme Court's judgment in the FCA test case. My name is Michael McParland. I'm chairing this panel today before you to discuss the decision which was handed down on the 15th of January. And as you know, it involved the Supreme Court considering some 21 types of policies issued by 8 insurers. And the FCA themselves think that the decision now has put an end to legal arguments under 14 types of policy issued by 6 of those insurers, and a substantial number of similar policies in the wider market will now lead to claims being successful. Now, they identified some 370,000 policyholders holding 700 types of policies issued by 60 insurers. So that puts the kind of scale of this decision in some perspective. Now, before we discuss the 6 main issues that were decided by the Supreme Court, I have the great pleasure of introducing the panel to you. Now, it's hard to tell on the Zoom screen where anybody is, but in the deeper blue shirt is Jonathan Bellamy, whom Legal 500 is a well-known insurance practitioner and commercial practitioner, both here in the Far East. Legal 500 describes him as a highly astute legal mind, which I will testify to, and always has an eye on the commercial goal of the client, was the Legal 500 in Asia Pacific said. And it's great to have him here. And further along in the less blue shirt, I think on the last seminar in September, Neil wore pink to distinguish, but we're dealing in shades of blue, is Neil Block QC, who really needs no introduction. He's described in this year's Chambers and Partners as a sublime barrister, very clear, sensible, and concise, and one of the best silks around, very hardworking, bright, tough, and determined. Now, many of you will know him, but thank you for joining us. I see I'd like to say good morning, but from people coming from the Far East and the Western Seaboard of Canada and all places in between, I don't know what time it is, so welcome. Now, as I said before, there were 6 major issues decided in the Supreme Court's decision. And the first of those we'll touch upon is the interpretation of disease clauses themselves. Those are clauses which cover business interruption losses resulting from any occurrence of a notifiable disease, usually within a specified distance of an insured premises. And the example that was the main model used in that was from the RSA Policy 3, which provided for interruption or interference with the business during the indemnity period following any occurrence of a notifiable disease within a radius of 25 miles of the premises. You know, it has a sort of Victorian feel to it of water pumps in 7 dials being affected with cholera, but of course it's the legacy of how clauses have been drafted. Now, as you all know, the insurer's position throughout was this should be given a very narrow interpretation, that it was only really concerned with cases of notifiable diseases occurring within a radius of 25 miles and losses under the policy that could be shown actually resulted from the occurrence of the disease within that radius, so sort of pitting the tail on the donkey, which is exceptionally hard for any policyholder to prove. The FCA's position was broader, and that was accepted by the High Court below in September. Now, I think everyone knows that the Supreme Court, and I'm going to ask Jonathan about this first, took a different view. So, Jonathan, how did they interpret the RSC Policy 3 clause, and how did it differ from the High Court's judgment?
Well, Michael, thank you, and welcome everyone to the webinar. As you've said, Michael, the Supreme Court's decision on this point was really legally different to the High Court. In practical terms, you make very little difference on the facts of this pandemic, unless, of course, you run a pub in the Isles of Scilly or in the Western Isles. But what they did was preserve the integrity of what the minority called radius limitations. And it's a critical part of this sort of cover that there is a geographical area. And the Supreme Court were keen to preserve that. And to an extent, therefore, legally, to an important extent, rejected some of the FCA's arguments that were accepted by the High Court, that the trigger for the insured peril was the pandemic itself. And what they found in the Supreme Court was that there had to be a case of illness within the geographical area, and that was clear, they said, from the words, and that to find it in any other way would be, in their words, to rewrite the clause. Now, importantly, what they then went on to find after a more restrictive interpretation on the construction was, of course, as we'll discuss later, a wider interpretation on causation. But it's important, probably for future insurance policies, which include different types of claims with geographical limitations, to note that on this point, the majority took a more insurer-based analysis than below.
Now, Neil, there were some other policies as well, which weren't quite the same wording as RSAs. How did the Supreme Court deal with them?
The slightly amusing starting point for all the questions we're going to look at today is by the time the Supreme Court have finished, 7 judges have now looked at these policies, and the Supreme Court was able to say, well, it's simple, really. The test in interpreting the policy wording is how it would be understood by the reasonable policyholder. One wonders if it was that simple, why we had to go through 7 judges to get there. But the short answer to your question, Michael, is that the narrower construction that was placed on the RSA policies was in effect placed on all the other policies. But as Jonathan trailed, the findings on causation mean that cover under the disease clauses was in all cases operative. One of the distinctions in the QBE policies was, rather than occurrence of a notifiable disease or illness, as in the policy Jonathan was just looking at, the wording was used manifested by a disease manifested by any person whilst in the premises or within a 25-mile radius of it. And it's unsurprising, really, that the bottom line is that all policies require there to be evidence of an illness, that's one person, within the jurisdiction. I think that's a fair summary, really, of how the court dealt with all the disease clauses.
Is it a little artificial, or just because in the context of a pandemic like this, there's no real dispute that there will be somebody within that radius? But can you see problems arising, either of you, in relation to, shall we say, less widespread diseases?
Michael, I'm just chipping in. That's what I was mentioned about the Isles of Scilly and the Western Isles. It's only really in cases where you could find a discrete geographical distinction where there have been no reported cases that this would make a difference. But Neil, what do you think about that question from Michael and other points?
I suspect that when we look at business interruption clauses written in the future, insurers will be asking the question whether they can reasonably reduce the radius from 25 miles as one of the fundamental questions. It's a contract. I don't see why they shouldn't, provided they bring it properly to the attention of the policyholders.
Reminds me of all those disputes about restrictive covenants, that were very popular at one stage, and maybe back in this life in this. Now, the second major issue that the court was concerned with was the prevention of access and hybrid clauses. Now, prevention of access clauses cover obviously business interruption resulting from a public authority intervention, preventing access to or the use of the business premises. And hybrid clauses contain both that prevention of access elements and the disease clause. Now, in the policies that were before them, they were concerned obviously with the prevention or hindrance of access to or use of the premises as a consequence of government or other public authority action or restrictions. And all the policy words had restrictions such as prevention, denial, hindrance of access to the premises due to actions or advice or restrictions of imposed by order of a government, a local authority, the police, or another body, due to an emergency to endanger life or a neighbouring property incident within a specified area. And the Hiscox 1-4 policy, which was a main one, provided for business interruption caused simply by your inability to use the insured premises due to restrictions imposed by a public authority. Now, Jonathan, how did the Supreme Court define restrictions imposed? Because we knew the court below had taken the quite a formalistic view as to what was needed. How did the Supreme Court react to that?
Well, Michael, I can freely say that I didn't foresee that the Supreme Court were going to do this, and I think anyone who's got the time to go back to the our webinar on the first High Court decision will say that I thought this was absolutely right, that the High Court had decided for reasons of certainty that it should be legally enforceable, but rather like greater minds of the majority, one can change one's mind.
Yeah.
The point here is that the Supreme Court took a more purposive really approach and said that they recognised the insurer's arguments about legal certainty. But they then said, well, this might penalise the socially responsible policyholder. That was a phrase they used. In other words, a policyholder who responded to advice given by the Prime Minister, amongst others, and closed the premises immediately without waiting for a legal obligation. I think for me, linking back to the point that Neil made a moment or two ago about construction, we're back to the concept of the reasonable policyholder and the importance of that, which I think is very interesting, not only in business interruption, but even more generally in insurance law as a result of this decision. Here, they're prepared to sacrifice some certainty for what they consider to be more justice. So restrictions imposed, it's got to be clear and mandatory. It's the only judgment I've ever seen which annexes statements of a sitting Prime Minister.
Well, it does say is Boris Johnson's statement on the evening of the 20th of March, where he told named businesses to close tonight. Obviously, he's making law as in his press conferences now. We should all follow Boris, apparently. What do you think, Neil?
Well, interestingly, as Jonathan says, the court chose to look at whether an instruction was mandatory rather than whether it had the force of law. And they gave an example of a public health officer who discovers vermin when inspecting a restaurant, immediately issuing an instruction to close the restaurant, although the legal order to do that may have followed several days later. And the court said, well, everyone would assume that there was a power to close it forthwith, and that the consequences of that should take effect immediately, not at some later date when a legal order was made. But as Jonathan says, we may have problems of interpretation, but in practice, I suspect it's whether a business interruption at the beginning of a period of a matter of days or weeks is recoverable or not.
Would there be a sliding scale of ministerial responses? You know, obviously it was the Prime Minister in this case, but would a statement from Matt Hancock carry the same effect, one wonders? Just thinking, as they say.
Well, only in the sense, Michael, that of U-turns. How do you deal with a U-turn?
Right, now one of the really, I thought, one of the most interesting aspects of how they dealt with the prevention or hindrance of access clauses is when they dealt with the triggers as what triggered them. Now, they dealt with three particular concepts, and the first of those was the inability to use. Now, the High Court had thought that meant a complete inability to use the premises, save for use that is de minimis. So, you know, you're locked out, you may have a bookshop, you're locked out, you can't sell, but you may be able to go in and, you know, do your books or tidy the place up. Now, of course, they use the example of the bookshop. How did the Supreme Court deal with this, Jonathan?
Yeah, well, as you've said, Michael, the first instance court took the approach of inability means inability, complete inability. And that raised the difficult question, what do you do with a restaurant that previously was a restaurant, now does takeaway? And as the majority gave the example, what do you do about a golf club that has a golf course as well as a hospitality business with the clubhouse? And what they decided was that inability does indeed mean complete inability, but not taken of the whole business itself. What you've got to do is see whether the policyholder is unable to use the premises for a discrete part of its business, or if it is unable to use a discrete part of its premises for its business activities. Now, that's at paragraph 137. It requires a little bit of cold towel around the head. And that rather amusingly concludes with the court saying, to that extent, it's binary. But what it means in effect is that if you have to close your restaurant facilities but continue takeaway, that's a difference in outcome. The department store with a pharmacy section which continues to operate is another good example of why the Supreme Court found that that should not prevent policy coverage.
Yeah, no, the example I thought particularly clear was the one of the travel agent. The travel agent with 50% of businesses walk-in customers, 25% internet sales, and 25% telephone sales. It could only claim in relation to the loss of the walk-in business. Now, you can see that.
Absolutely, and that's the corollary, as you rightly say, Michael. What the Supreme Court were at pains to make the point was that the FCA did not argue that in those circumstances the loss would cover the whole business. As you've just said, particularly now interesting with online sales, very interesting now with the migration of digitalization of the high street, which is probably irreversible. You've now got to look at that aspect of the loss, which was indeed unable to be pursued.
Neil.
It leaves interesting questions of causation and quantum. If one, for example, has a clothing business and the store has to close and the business loses £1 million, but in fact its online trade goes up by £1 million, logic would suggest, and I would suggest, that the reasonable policyholder wouldn't think they had a claim, even though they'd had to close their store because they'd not suffered a loss of profit. But I'm sure there's a range of views on that.
Yeah, well, it'll be interesting. Again, it goes with the trends issues. Probably we're going to talk about it later on. Now, prevention of access was their second one. Jonathan, what did the court deal with the question of prevention of access? What was needed to prevent access to the premises?
Yeah, well, again, it dealt with it in a very similar way, Michael. An example of that, as I said, really was the restaurant with sit-down facilities that has moved to a takeaway only example. It did say, importantly on this particular point, that interruption means interruption. And that's a general point that runs through this judgment. Let's remind ourselves, this is the first time that any business interruption policy has been considered by the highest court in this country. And therefore, what the court says is very important in general terms. Interruption did not mean there had to be a complete cessation of business under this part of the case. Interruption means interruption. And it referred, of course, to the standard terms of such policies, which have increased cost of working, which necessarily means that there is still work being done. But essentially, the analysis was the same for prevention of access into the two binary aspects of prevention.
Neil, can I ask you, and what do you think is the significance for policyholders of the court's interpretation of prevention of access in the hybrid wordings?
I think to some extent one has to look at the overall scheme of the judgment, go back to look at the definition of disease and the geographical clause, and the court is saying that if a policyholder can establish that at least one individual within the geographical area comes within the policy wording for disease, then if there is nationwide decision to close down the business, or that has the effect of closing down the business, then policyholders should be able to recover. It's really back to looking A, at disease, and then B, at access. But they're all linked. The court is saying, well, the policyholder has paid a premium in the event that they can't operate their business because of an insured cause, and therefore they should recover.
Well, that insured cause, of course, brings us on to perhaps the biggest issue, issue 3 in the case. I say biggest because it took up 90 paragraphs of the judgment. So it's the question of what causal link must be shown between business interruption losses and the occurrence of a notifiable disease or other insured peril specified in the judgment. Now, it was a battle between the but-for test and, shall we say, the relationship with the test of proximate cause. Now, what did you make of that, Jonathan? What did you think about what role did the Supreme Court think the but-for test should actually play in interpreting disease clauses, for example?
Well, I think, Michael, you're absolutely right. This is a huge part of this judgment. And the very fact that the Supreme Court spent so long on it seems to me, at least, to send a message that this is their thinking, not only on business interruption, but quite possibly on other aspects of insurance law loss. Now, having said that, it is important to note, and this was made at paragraph 181, that the majority, and on this point the minority did not depart, accepted the argument from insurers that, and I'm going to quote very briefly on this, quotes, that the vast majority of insurance cases, indeed in the vast majority of cases in any field of law, required the but-for test. So one mustn't get carried away with the approach that the court took, in my view, in this case more generally. However, what they did in this case was reject clearly the insurer's but-for analysis. In my view, principally because it would have defeated the commercial insurance purpose, the whole underlying purpose of the insurance contract, and that they were not obviously prepared to do. And what you've got developing out of this is a concept of proximate cause, as you've said, in the red corner and the blue corner, and on this one, proximate cause 1, and the development, which I think we'll probably talk about in a few minutes, between concurrent causes, in particular concurrent causes which are non-excluded. So the simplest answer to your question is that the but-for test will be considered. It is certainly not determinative, and where it threatens the underlying purpose of the insurance policy will be rejected. And at one point, the Supreme Court said it is neither a necessary nor a sufficient test. And it went into quite an interesting analysis of why that was the case. It can be read rather than expanded on in this short webinar about its faults. And one particular example, which I can relate to a question we received later about 2 fires, is a good example of that.
Right. Neil, what did you make of those 90 paragraphs of fun and frolics to consider?
I think one has to step back and, as Jonathan says, look at the purpose of the insurance contracts, and whether one's looking at a widespread disease, an epidemic, a pandemic, or a natural disaster such as a hurricane. If that's what one has insured against, then should one be deprived of the fruits of that policy? Because it's not just the business or the immediate area that is affected, but it's a wider area. So if you insure against hurricane damage that is limited just to your area, then you recover on the but-for test or any other. But if it's a much wider area, then you don't. And the same with epidemics or pandemics. And the court was concerned that if you can establish that your business has been interrupted by reason of COVID-19, that not only affects your premises or your radius, but affects the whole country, then that's what you've insured against, and you should recover. And there shouldn't be a defence. Well, but for the outbreak in your premises, you still wouldn't have been able to trade because of the outbreak next door.
We'll come on to the Orient Express.
It is.
Of course.
We've tried to keep it separate, but we're looking at when there's more than one effective cause. And interestingly, the Supreme Court said that you could perhaps treat every single person who tests positive as being an effective cause.
Yeah, that's true.
There can be dozens or hundreds of thousands or millions of effective causes, if that makes sense according to the policy.
Well, we knew we were turning into some medieval philosophers counting angels on the heads of pins when you see at paragraph 164, when they start talking about how the maxim proximate cause arose with Francis Bacon in 1596, but it was sort of supplanted in the 19th century by Aristotle's notion of efficient cause. So we know we're engaging in a very theological gray area in some aspects. But do you agree with Jonathan, Neil, that in reality, you can't be able to use this case to launch an assault on the but-for test?
I have always understood that the starting point on causation is the but-for test, but there will be circumstances in which that's not appropriate, and we've wrestled in recent times with how the courts have looked at asbestos-related illness and the Fairchild analysis, where the courts have again moved away from the but-for test in order to do justice and in order to avoid the situation where there are a number of causes, but a claimant cannot say that but for that cause I wouldn't be in the same situation. It's a way of getting around that evidential difficulty, and it's illustrated here by the situation. Is it sufficient for a claimant to prove that the interruption of their business was as a result of government action taken in response to cases of the disease, which included at least one case within the geographical area, or is it not? And the Supreme Court considers that that is all that is required.
Michael, I was just going to chip in and say I absolutely agree with, in particular, 2 points that Neil's made there. The first is that this analysis, if I hadn't made it entirely clear before, but deals with multiple concurrent causes, and that's very important to bear in mind. The second point is that the Supreme Court specifically said, paragraph 190, that this is context specific. And again, a short quote, it's worthwhile bearing in mind though, where the context of a claim under an insurance policy is under an insurance policy, judgments of fault or responsibility are not relevant. All that matters is what risks the insurers have agreed to cover. And that must be the point that Neil's making, and I agree with it. And I think that's the clearest paragraph or phrase within the paragraph which establishes that.
Now, Neil, the next issue which has exercised their lordships was, of course, trends clauses, which obviously is of great interest to policyholders and even more interest to the insurers, which of course the effect of them is to prescribe a standard method of quantifying the business interruption losses by comparing the performance of the business at an earlier period of trading. Now, the example, the Hiscock 3 example, which they focused on, had business trends, and the wording went, the amount we pay for loss of gross profit will be amended to reflect any special circumstances or business trends affecting your business, either before or after the loss, in order that the amount paid reflects as near as possible the result that would have been achieved if the damage had not been caused. Now, what guidance did they give the Supreme Court? What did the Supreme Court give regarding the interpretation of these trends clauses, Neil?
First of all, the court started off by saying trends clauses are part of the machinery of insurance for quantifying loss, and in accordance with the general principles that we've been discussing so far, they should be construed consistently with the insuring clauses in the policy. And the way that the Supreme Court has generally approached all of the issues that we've discussed is to compare the pre-COVID position with the post-COVID position. And when one starts with that as a launch pad, it's not difficult, if there's anyone in our audience who hasn't guessed the conclusion, that the court is saying one must disregard the effect of COVID in the wider area. If one establishes that a cause of business losses was COVID, then one compares that to the pre-COVID trading position. And I have to say that is, it seems to me, a matter of logic that the policyholder would expect. How much did I earn the year before COVID reared its head, and how much did I earn in the year subsequent? And the difference is my loss.
Now, Jonathan, the FCA regard this decision on that point, the trends clause, has been quite significant for policyholders because a number of insurers had refused cover or greatly reduced cover in a lot of cases because of their interpretation or restrictive interpretation of these clauses. What do you make of that for policyholders who are now contemplating looking again at their policies?
Oh, it's very significant indeed. As Neil said, the simplest way of putting this is that trends clauses have been clarified as being part of the quantum mechanism and not to do with the scope of the indemnity. And the second point in my book is paragraph 268 makes it clearest. As Neil's just said, what one does is consider trends which are, quote, unrelated to the insured peril. And I agree with Neil. I think that that's what reasonable and possibly even an unreasonable policyholder would expect. Now, as to the question of importance, extremely important, because this threatened to be a device in relation to claims that would stifle a lot of claims. Now, whether one's advising a policyholder or advising insurers, it doesn't matter. The point is to understand the importance of excluding the consequences of the underlying peril from the trends clause. And I am confident that this particular finding will stimulate a very significant number of claims that would not otherwise have been brought. And it's also right, as indeed the court mentioned, a lot of these policy claims are not big, they're five-figure figures. And it's for the SMEs and relatively modest sums in litigation terms, which is one of the advantages of a group action, of course. But this point will impact those claims.
Now, of course, linked on to that was the fifth issue of how do you actually calculate the pre-trigger losses? What is the significance in quantifying losses of the effect of the pandemic on the business, which had occurred before cover was triggered? There's a pre-trigger. It's not a only fools and horses type moment, but it's before trigger comes on the scene. Now, at first instance, the High Court had held that the proper operation of the trends clause was such that if there was a measurable downturn in the turnover of the business due to COVID-19 before the insured peril was triggered, then in principle, the continuation of that measurable downturn and or an increase in expenses ought to be taken into account as a trend or circumstances in calculating the indemnity. Now that led to a very complex declaration. It's mentioned at paragraph 289 of the judgment, which was declaration 11.4 C and D in the High Court's original judgment as to how it should be calculated. Now, the Financial Conduct Association, we know, thought that this could really significantly reduce. And the Supreme Court gave the example of the pub that suffered a 30% downturn in turnover during the week ending 20th of March, before Boris Johnson told everyone to stop, to shut, due to the fact that people simply were worried about COVID-19. But having been ordered to close, did that downturn in turnover, that 30% down turnover in the pub, should that be taken into account? Now, Neil, what do you think how did they deal with this and the logic of it?
Well, the logic is that, as I was just saying, one goes to the point at which, or prior to which, the business was affected by COVID. So in that example, and obviously this doesn't work in the real world, one would look at the weekly income 2 weeks before the trigger event, if it was only the final week before the trigger event where there was a downturn. And what one's trying to do is to see the usual trading profits unaffected by COVID, and to compare those with the reduced trading profits as a result of COVID. And that will usually be the loss.
Now, Jonathan, I always feel very comfortable when examples are given using a pub as an example, because you feel that's the common law in action. We really know where we are, that a pub may be affected by this. Now, taking into account, assume the pub has suffered a loss, what guidance has been given regarding all the attempts by the government to keep people afloat with various loans and the like? Were they to be taken into account, do you think, in the analysis of the downturn?
Well, as Neil said, one's got to strip out, so to speak, the effects of the COVID pandemic in the quantification process. Now, on this point, we've received, one of the questions we received relates to guidance given by the FCA in relation to what might be taken into account in assessing loss. Now, as one of the points the FCA have done is issue some correspondence already before the hearing about what should and should not be taken into account. Now, those are not legally binding indications. I know Neil's got some thoughts on the extent to which claims in relation to rent are viable. Two particular areas here are furlough payments and repayable grants. Now, my own approach to this, the starting point, if you like, for first principles, would be to take into account first that it's an insurance claim, and secondly, to consider how the law generally treats collateral benefits. And that general approach is not to give the insurer the benefit of those. They're, if you like, res inter alios actor. They're separate contracts or statutes which grant payment. Neil, I know that you're fully aware on this point, having looked at the FCA correspondence. Yeah. What are your thoughts on this?
Well, the guidance is that payments through the various government schemes should not be treated as turnover. It's easy, I would have thought, for everyone to see that in the case of loans on preferential terms, because those are going to have to be repaid. With regard to furlough or any concessions that may be made with regard to rates or other overheads, it's a separate scheme. It's subject to the terms of that scheme, and the insurer shouldn't take the benefit of it. It's certainly the statutory scheme with regard to giving credit for other benefits in other spheres, such as ill health, I would have thought that the courts will take the same view as the FCA guidance, and indeed the letter that the FCA wrote to the CEOs. I think there are still a number of outstanding issues. That is one. An issue that I suspect is going to arise is in terms of aggregation. How many losses, events or occurrences are involved under the policy? What happens if there are multiple premises? What happens if there's only local lockdowns and we've got our tier 1, 2, 3 and 4? And what happens if there are national lockdowns? So that there's still plenty of potential for argument with regard to quantum. As Jonathan says, there's a big distinction between quantum and in coverage entitlement.
Right. Well, the final issue 6 that the court dealt with was in relation to the interpretation of causation and interpretation of trend clauses, was the status of our old friend, the commercial court decision in Orient Express Hotels against Girone Generale SPA. From 2010, the Orient Express case, which concerned, as people will remember, the attempts by a hotel in New Orleans to recover business interruption losses caused by Hurricanes Katrina and Rita. Of course, we had an odd situation, and that was decided by a panel of 3 arbitrators, which included His Lordship, now then George Leggett QC, as an arbitrator, and on appeal to on a point of law to the commercial court, it was decided by Mr. Justice Hamlin, both of whom, of course, gave the lead decision here, and both of them decided that they'd been wrong at their 2 levels of that, which is, as we all realize, looking back on things. Now, Jonathan, what did you make of the analysis of how could we be so wrong for so long?
Yeah, well, I think this is a really interesting general point to be made here about first instance precedent. The Orient Express case was decided in 2010 and has been regularly relied on and advised upon since then. It arose as a result of an appeal under the Arbitration Act from arbitrators. And as anyone involved in that area will know, the powers of the judge are limited to areas of law arising out of facts found and arguments run before the arbitrators. And it's also a short hearing. As Lord Hamlin made the point, he was dealing with a single day hearing. Now, for me, one of the interesting points here is that Hamlin J, as he then was, gave permission to appeal to the Court of Appeal in that case. And you don't do that very often, certainly not on an appeal from an arbitrator. And he certified a point of law of public importance. And the appeal was settled. And one could only imagine why the commercial interests of those involved were content with the particular first instance judgment and didn't want that overturned. The effect of it impacted both the approach to concurrent causes and also to trends clauses. And as we've just been discussing, the Supreme Court in this case, which happened to involve the 2 judges on their different ways, reversed their positions on that. So there's no doubt where we are now. The minority made the point, Lord Briggs said that Orient Express should rightly be overruled. So we're no doubt that everyone's agreed that they were wrong. But as someone once said, when having an appeal, when asked for permission to appeal, the applicant asks, well, I'm applying because you're wrong. And he says, well, I'm right because I'm right. And he says, yes, but you'll be wrong when it's found that you're wrong. So I think that's the interesting point. And we know where we are now with Orient Express, but what do we do with those other first instance cases, particularly in insurance law, about which there's a lot of uncertainty? And a lot of the case law since then has been decided in confidential arbitration, which doesn't provide a precedent.
Neil, were you at all surprised by them overturning Orient Express?
No, I advised a number of policyholders prior to the FCA commencing this litigation. And I said, well, perhaps if we just sit back, you won't have to be the one that takes this to the Court of Appeal to overturn Orient Express, because I think it's wrong. For me, there's not much amusement in the Supreme Court decision, but when Lords Hamlin and Leggett unequivocally overturn their previous views, they give us the benefit of some earlier views of the judiciary on their own precedents. And here's a little passage from here. Perhaps Dr. Johnson really went to the heart of the matter when he explained the blunder in his dictionary. Ignorance, sir, just ignorance. But an escape less self-deprecating was taken by Lord Westbury, who, it is said, rebuffed the barrister's reliance upon an earlier opinion of his lordship. I can only say that I am amazed that a man of my intelligence should have been guilty of giving such an opinion.
Well,
their lordships took it on the chin.
That's very nice. Now we've come to the end of those 6 issues, and I just have a little tell you. I know there's been lots of questions coming in, and Jonathan's been looking at that. We hope to spend a few minutes on that. But before we do, can I just tell you what is anticipated next by the FCA? And the first of it is that the Supreme Court's decision will be distilled into a set of declarations, as was the case at the first instance. And they hope to have that done as quickly as possible. So the court will issue the declarations after hearing the parties. Now, once that happens, the FCA say they're going to publish a set of Q&As for policyholders to assist them and their advisors in understanding the test case. So that will be a valuable guide, particularly for lay people. And then the FCA will publish a list of business interruption policy types that potentially respond to the pandemic based on the data they're gathering from the insurers. And they've also published a draft guidance for policyholders on how to prove the presence of coronavirus, which of course is a condition of the policy. There's a consultation going on at present, which they've extended, I think, extended to 22nd of January for any supplemental comments arising from the judgment, and they'll keep appraised. They've been very good at keeping everyone informed. So that's what's likely to happen next. So we've got a few minutes before we end, and appreciate that. Thank you for sending questions in. There's a lot of them, so I'm afraid we won't be able to get to all of them. But Jonathan, can you
yes.
kick us off with anything that's...
Yeah, but Michael, as you say, we've had lots of questions, and as ever, we'll do our best to deal with some of the more general ones that might engage the listeners, of which there are a large number, the best. We will endeavour to reply by email briefly, if we can, to the more specific ones. One of the first ones really relates to the construction area here, and that's from an insurer interest who comments and remarks on the fact that in the RSA policy there was a general policy exclusion. I think, as Lord Leggett said at page 93,
yeah.
He said rather pointedly in the judgment.
Having looked at page 13, having read to page 39, would they have gone on to page 93?
That's it. How many policyholders actually get to page 39, you may think. That's what key facts documents are for, aren't they, really?
Yeah.
For us all. But joking apart, what can you give with one hand and take with the other, particularly if the giving is at page 39 and the taking away is at page 93 in small print? And one of the phrases, so he asks for our comments. I'm going to open it up, obviously, to both of you. I'll just say this for my own part, because this is an interesting part. The phrase used in the Supreme Court was that it would, quote, obliterate the cover. Now, that is by the standards of the measured language used by appeal judges, pretty severe in my view. And I think it does give an indication of the general approach of the courts, not only in business interruption, but more importantly in general claims and insurance policies. And given Lord Briggs's paragraph 316, I wonder what he would have said had he been writing the judgment on this point. Michael, you've been asking the questions, and
Yeah, I thought for this, for that.
Let me turn the tables on you and ask you what you think about the extent to which those comments might impact the efficacy of that type of general exclusion in other more general contexts.
I thought that the point they were taking was a very bad one. And the acid test, obviously, as an advocate, I've thought of many years, whether a point's good, bad, or indifferent. The ultimate acid test is, can you say it with a straight face? And standing in front of their lordships saying, well, actually, we're going to exclude liability under the terms they were doing based on this small print at page 93, which, as you say, they thought would obliterate the whole purpose. That failed that straight face test. So I think the lesson is, is don't take real, that was just daft for the insurers to try and do that. I know in desperation, whatever, but it was just daft. Am I being too harsh on them, Neil?
No, it's a general exclusion clause. I have to say that I was asked to advise on this a number of times, and it did cause an anxiety because it was there, and on the face of it, it excluded liability for disease in the context of an epidemic. But it's difficult to put the insurer who takes a premium for business interruption by reason of disease in a favourable position when they then try to exclude liability just because that disease is widespread.
Yeah. Jonathan, anyone else we get time for?
Yeah, I was going to move on to another question. I'm slightly generalizing this question to make it more relevant to others, but there are a number of references, the question is, to, as Neil's mentioned himself already, and I've touched on, the natural and reasonable reading is a phrase which is used on several occasions, Michael, isn't it? And also the reasonable policyholder, and the construction of policies. Now, a few years ago, we had at the highest level in the Supreme Court Wood and Capita Insurance, which is one of the leading cases on construction of contracts generally in an insurance context. Now we've had this. There's no indication, as far as I can see, I'm partly answering the question from my perspective here, that the comments are limited to business interruption. I wondered, Michael, first, what you thought about the general normative, if you like, application of the policyholder-friendly interpretation that the majority and also, of course, the minority applied to insurance policy construction in this case.
Well, I got the impression that really it was a perfectly fair balancing exercise of what the purpose of insurance was. The insurer, the insured took out a policy to protect certain risks, and the insured for the premium gave it. So the court was saying, right, okay, that's the deal. We are going to uphold that deal. I found it, among all things here, that they treated, insurance policies as a contract and not to be honoured, and not to be just to be something which provides a template whereby they could get out of the obligations to do it. I thought it's particularly acute for something like business interruption insurance in relation, because that clearly is of grave importance to many small businesses, often an adjunct to more important insured risks such as protection of property or assets. But it's meant to be honoured. I felt in that respect, though I didn't get any sense of that this was particularly claimant friendly. I thought it was a well-balanced piece of work. I don't know whether you agree, Neil, or?
Well, it's an invitation to insurers to review their policy wording, because whilst I know, because I often have this discussion with insurers that said they do, what happens is that policies tend to be cut and pasted largely from other policies, and then we have brokers' wording that goes in as well. And what the Supreme Court is saying is, if you wish to exclude a liability, you're free to do it as an insurer, but you must do it clearly so that the reasonable policyholder understands that they do not have cover for a particular event. And the court made it particularly clear when considering causation that where there are concurrent effective causes, then liability will arise in respect of both of those causes unless there are clear and express words excluding one of them. And so, in a sense, the ball is in the insurer's court to ensure that their policy wording is tight, and insofar as there is to be an exclusion, that is made clear.
Do we have time for one more very short one, Jonathan?
Michael, I think we do just have time for just one more, as you say. Again, I'm going to just summarise the points made here. This is a question about the but-for test, causation, reflecting, I think, its importance in practice to practitioners. And it's given in the context of a construction dispute involving defects requiring remedy, which may be due, for example, by the construction professional on the one hand, who will be insured in all likelihood under professional indemnity policy, and the contractor, who may or may not be insured, but if a design and build likely is. So you've got two potential causes here of loss which requires remedy. And it can't be said that either satisfies the but-for test. Where does this judgment leave that analysis is in effect the question. And the specific reference to one paragraph of the judgment, paragraph 178, when counsel for Amlin raised a rhetorical question, daring, if you like, the FCA to find a case in which the but-for test was actively not satisfied. Now, just kicking off our response on that, seems to me that the answer is probably most clearly given in paragraph 181, where it talks about the but-for test not being determinative and being applied only as a necessary threshold in appropriate cases to be context specific. It's right on my reading of the judgment that that rhetorical question wasn't answered by the court. But I think the answer really is given in paragraph 182 with the Heart and Honour example, the two fires, which I touched on right at the beginning of this webinar. So very briefly, two fires start at the same time, cause the same damage. It can't be right, can it, that neither defendant who started the fire is liable for loss. What do you do? And I think it's really that which decides it. Firstly, one's got to look at the reality of the situation. It can't be right that neither party's liable. It is context specific. Neil, what do you think about that?
I think the starting point is to see if the but-for test can be applied and can do justice. And where it becomes clear, as in your example, that there are concurrent effective causes, then I would expect a court to say that provided that one of those wasn't excluded by contract, that whoever is liable in respect of each of those causes has a liability. And the court may then go on to apportion as between the two. But it wouldn't be right that one ends up with a claimant with no defendants.
Well, I'm afraid we've run out of time, gentlemen. It's now time to say goodbye to everyone who's been watching us. This has been recorded, as are all our webinars, and they're available on Chambers' website, as are numbers of articles, both by Neil, Jonathan, and myself on various matters, and other members of Chambers that I hope you find interesting. Contact Charlie or Beth, and they'll point you towards them. I'd like to thank you for joining us here today and for your questions. I'd like to get Jonathan and Neil to say their farewells before I sign off.
Yes, well, thank you very much indeed for taking the time to listen to us. It's been a pleasure.
Yes, thank you. And I've just been looking at the questions, and it seems to me that there are a lot of questions which need detailed legal advice, and now you know where to come.
Yeah. Well, on that happy piece of advertising, may I wish you all a safe period of time in these troubled times. Good luck. God bless. Take care.
Thank you.
Oh.